I'd like to call to order the Hatfield Township Board of Commissioners regular meeting for April 24, 2024. Roll call.
President Zipfel.
Here.
Vice President Rogers.
Here.
Commissioner Andrus.
Here.
Commissioner Lestracco.
Here.
Commissioner Partha.
Here.
I would like to ask our solicitor, Kristen Pianzio, to lead us in the Pledge of Allegiance this evening.
Of the United States of America. Republic for which it stands.
So this is like a regular crowd for us. It's actually a little small. It's a little on the small side. So, actually, we really appreciate everybody showing up. We do not, as you can imagine, get many people to come to our meetings. And so this is a little unique for us. And it's also exciting. It's happened a few times. Every year we get 2 or 3 times where we get a large crowd, and it's always enjoyable. Before we get started with our hearing, we do have a couple of things, some housekeeping items, and actually Representative Malagari is here to present a very nice check that he was able to acquire on the related to the police department. I'll let him, I don't want to steal his thunder, and we'll introduce him. So we've got a couple of things to do before we get to the exciting stuff. So just give us a few minutes, bear with us. And if you find it tremendously interesting, always come back every second and fourth Wednesday of the month. We like to have people here. So, all right. Commissioners, is there a motion for approval of tonight's agenda?
So moved.
Motion by Commissioner Andrus.
Second.
Second by Vice President Rogers. Any questions or comments with regard to the agenda that's before you and on the screen? Hearing none, I'll call a question. All in favor of approving tonight's agenda, say aye.
Aye.
Opposed? Hearing none, we can move ahead. Consent items. Is there a motion to move the consent items that are in the agenda into the record?
So moved.
Motion by Commissioner Lestracco.
Second.
Second by Commissioner Partha. Those consent items include the Board of Commissioners meeting minutes for March 13, March 27, and April 10, the Treasurer's report for the month of April, and the bills payable, paid bills in the amount of $460,028.78, and unpaid bills in the amount of $522,535.72. With that, I'll call a question. All in favor of moving those into the record, say aye.
Aye.
Opposed? Hearing none, that is approved as well. Okay, I know here, everyone is here for citizens' comments to some extent, but unrelated to the hearing that we're going to have, are there any citizens' comments on agenda items? Okay, seeing no one run over to the podium, we have one special item. Representative Malagari is here to give us a check presentation from his office. It is a grant for our police station, I believe. We're very excited to have him. Always thankful that all the hard work that he puts in for us. And Steve, the podium is yours.
Good evening, everyone. I know that you're all here because of this check presentation and because I was part of the welcoming committee. Mr. President, thank you for having me this evening. To the members of the commission and to the board, thank you. I really do appreciate being here. I'm really proud to be able to present a check, an oversized check, a big check for a multimodal transportation grant that actually is going toward help in developing some of the site for the new police station. It's going through some traffic restoration work and then also some sidewalk and some curbing and stuff like that. So it's my great honor to be able to award this check to you. I'll just ask that we have. If you want the whole board, you're more than welcome to, because this goes to all of you. Also, if you want a member of the police department here, that's fine too, or the chief. But this is a really cool thing to do for the entire community, and this helps all of us here as taxpayers. So really do appreciate it. And so we have a check to present for $393,750 to Hatfield Township on behalf of this project and toward the new police station. So, congratulations.
Yep.
So if you haven't heard, we are building a new police department. I don't know if we're clear. Representative Malagari has been on the township side, on the police department side forever. So I want to present you with a gold shovel for the groundbreaking from our new building.
Thank you.
Oh, cute.
Garden season.
Thank you very much.
Thank you.
All right, no, we don't normally get $393,000 at the start of each meeting. That's not a regular thing for us, so we're very excited on that, too. One quick action item before we get to the public hearing, so we'll jump right into it. There's a Resolution 24-14 with regard to an 18-month maintenance period for 2618 North Broad Street land development. Is there a motion for approval from one of the commissioners?
So moved.
Motion by Vice President Rogers, second by Commissioner Andrus. Aaron, do we need to really, we've discussed it at previous meetings.
Discussed it several times. It's simply a housekeeping item at this point. It's,
Right.
it's saying that the public improvements for that project on Broad Street behind Yum Yum and the Dairy Queen back there has been completed, certified by the engineer. Now we'll enter into an 18-month period to guarantee the performance of those improvements.
All right. Any questions or comments from the residents or from the dais? All right, hearing none, then I'll call the question. All in favor of Resolution 24-14, say aye.
Aye.
Opposed? Hearing none, that is approved. Okay, we are going to jump to our public hearing. It is a conditional use application from Pulte Homes of PA Limited Partnership with regard to 336 Orvilla Road. Ms. Solicitor, should I read the legal notice first? All right, so our legal notice in advance of this evening that was published appropriately is that the Commissioners will hold a public hearing to consider the application of Pulte Homes of PA Limited Partnership, which requests a conditional use pursuant to Section 28224.f of the Hatfield Township zoning ordinance to permit a single-family detached dwelling cluster development consisting of 78 houses on property located at 336 Orvilla Road, tax parcel number 3500-073690003, located in RA1 residential zoning district of the township. The board will consider any and all business that comes before it in its due course. All interested parties may attend this hearing and may be given an opportunity to be heard. Persons with disabilities who wish to attend the hearing and require auxiliary aid, service, or other accommodation to participate in the hearing should contact Hatfield Township at 215-855-0900. Hatfield Township, Aaron Bibro, manager, Kristen Pianzo, solicitor. That is the legal notice that was appropriately published before this evening, which allows us to move forward. And at this point, I get to hand the ball off to our solicitor, Ms. Pianzo.
Thank you. Good evening. I'm Kristen Pianzio. I'm the solicitor for the township. I'm the attorney for the board. And we'll start with the following board exhibits. B1 is the application dated on or about March 5, 2024. B2 is the conditional use plan prepared by Bowler Engineering, dated March 1, 2024. B3 is a deed dated January 3, 1983. B4, collectively redacted portions of an agreement of sale dated September 25, 2023. B5 is the proof of publication advertising this hearing. B6 is a certificate or certification of posting, and B7 is a certificate or certification of mailing. So good evening, everyone. I want to describe what is going to happen here tonight, what a conditional use hearing is. I've explained to the Board of Commissioners they're sitting in a different capacity than they're used to. The board is acting sort of like the zoning hearing board, sitting here in a quasi-judicial capacity, meaning they're sitting as judges here to judge the application that has been filed. The conditional use hearing has standards that are found in our zoning ordinance. They regulate how this goes. There's also a state statute that regulates how these hearings are conducted, and there is a whole body of case law that dictates how both of those things are interpreted. So although some issues are relevant to tonight's hearing, some things are not. Land development issues, I know from working here in Hatfield, the main two issues for all Hatfield residents are traffic and stormwater management. Traffic is relevant, but stormwater management is something that would be dealt with later. In the event this applicant gets past this conditional use proceeding, they would move through a process called a land development application process. And that's how the earth is moved, how the houses are laid out, ingress and egress, landscaping, stormwater management, lighting, things of that nature are part of that process, which is a very long process. It's when the engineers actually dig in and fully design the plans. That's not what's happening tonight. The only thing happening tonight has to do with use. They've asked to do a cluster subdivision. They have proposed a plan. The board does not approve a plan as part of this process, but it's what they feel meets the sections of the code. So as you can see, Julie Von Spreckelson is representing the applicant. She's sitting over there at the table. Tom Panzer has been appointed by the commissioners to represent the ordinance and make sure that it has been complied with. We have a court stenographer sitting in front of me. It is very important that the court stenographer gets everything down. That is the official record of this proceeding. If there's an appeal, what goes on the stenographic record goes up to court, as well as exhibits. So this has to move in an orderly fashion. One person speaks at a time. You have to be on microphone to be heard. And we're going to proceed in an orderly fashion. There is the opportunity, I want to start with our stop time, 10 o'clock. That's my goal. If we get close to 10, I'll ask the attorneys where you are in your case. If you're close to being done and we need to go a little over, that's fine. But we want to be reasonable. If we don't get through everything tonight, which I expect that we won't, we'll continue this matter on the record. So notifications were mailed out to a lot of people. There's a level of participation for people who are deemed parties, and then there's a level of participation for non-parties, and let's go over that. Parties can participate in this hearing by asking questions. They can present witnesses, and they can provide sworn testimony. Only parties to the proceeding can do that. If you're a non-party, you can make public comment, and that's at the end, unfortunately. It won't be tonight. If they don't finish tonight, it's at the very end of this proceeding. So how things will go is Ms. Von Spreckelson is going to call witnesses, and how many do you have, Julie?
Two to start, but there's possibility of rebuttal, of course.
Okay. So she'll call one witness at a time, ask questions of that witness. When she's done asking questions, the attorney, Mr. Panzer, will have the opportunity to ask questions, and then this board can ask questions. After that, the parties to the proceeding can then ask questions, and we'll do that and move through her witness by witness. When Julie is done, Mr. Panzer has the same opportunity to present witnesses, and then Julie will have the opportunity to ask questions, then the board, and then the parties. So we'll move in that fashion. In order to be a party, you would have to have gotten notice of the proceeding. Now, just because you got a notice doesn't necessarily mean that you are a person affected, as it's defined by the state statute, to participate in this hearing. And Ms. Von Spreckelson will have an opinion about who can be a party and who can't be a party in her opinion. Mr. Panzer may have an opinion as well. So we're going to start with figuring out who it is that wants to be a party. We'll establish them one at a time. Those within 500 feet will be considered parties. Obviously, Ms. Von Spreckelson can ask questions of people relative to how they're affected differently than other residents of the township. That is the level of scrutiny for tonight. In order to file an appeal of this hearing, if anyone's unsatisfied, you have to be a party. Doesn't mean that your appeal will be effectuated, but you're not eligible to appeal unless you're a party. Okay? So with that, I'm going to ask if people are interested in obtaining party status, you have to go to the microphone. I take notes, although there's a stenographer, I try to keep up. I'll ask that people spell their names, their first name and their last name, and give me your address. I have a list of those within 500 feet. Those are the people who have first dibs at becoming parties. So if anyone would like to be a party, please go to the microphone. Right, over there at the podium. You can line up, it'll save time. If you want to just line up one at a time, that'd be great. Yes, ma'am, what's your name?
Catherine Schutz, S-C-H-U-E-T-Z. Catherine, C-A-T-H-E-R-I-N-E.
Get notice of the hearing, Catherine?
I did.
Spell it again, S-C-H?
U-E-T-Z.
Okay, you're not on the list of people within 500 feet. What's your address?
588 Grapevine Drive.
Can you explain how you're a person affected other than a resident within the township?
The street I live on will be the street that connects to the new development.
Von Spreckelson?
Yes. I'm sorry, you said your address is 588 Grapevine?
Correct.
And how far is that from the subject property?
I don't know, I've never measured. It's not a very long street.
Okay, I'm going to object on the basis of we don't know the distance from her property to the subject property, and in addition, just living on the same street as the development is not a basis for being affected to have party standing.
Anything, Mr. Panzer?
Yes, Ms. Schutz, how many properties away from the subject property do you live on Grapevine?
I'd have to look. Yeah, maybe like 10? I don't know how many houses are on that street.
So,
About 6.
6 houses?
Yeah.
My position would be that Ms. Schutz would be entitled to party status. 6 homes is undoubtedly within 1,000 feet of Grapevine Drive, generally speaking, of the subject property on Grapevine Drive, which so far the plan shows as the only access road into the development.
I would just object to the characterization that it's obviously within 1,000 feet. There's no basis, it's speculation. I'd not like that in the record.
Okay,
There's a bit of speculation in that, yes.
Okay. Unfortunately, you're not one of the people within 500 feet, and since there's an objection to you having party status, you won't be a party. You will be eligible to make a comment, though, at the end of the proceedings.
All right, thank you.
Thank you. Yes, ma'am.
Hi, Donna Bushman, B-U-S-C-H-M-A-N-N. My address is 1648 Leon Drive.
You are on the list of people within 500 feet. Any objection, Ms. Von Spreckelson?
How far, may I ask a few questions? Sure. Please. How far are you from the subject property? How far is your property?
100 feet? I don't know. My backyard backs up to them.
And how are you affected by this application different than the average citizen would be affected by the application?
Because our backyards are going to share each other.
I'm going to object, just note my objection for the record.
Okay. Objection overruled. You have party status. Thank you, Ms. Bushman. Who's next?
Leah Hartzell, same address, 1648 Leon Drive.
Any objection, Ms. Von Spreckelson?
Yes, there's 2 people living at the same address. I'm going to renew my objection that I made last time, and really, if they're both living at the address, one would be sufficient.
Hartzel, Hartzell. Leah, Leah.
Can I have your last name again, Leah?
Hartzel, Hartzel.
Okay. I'm going to overrule the objection. She has party status. Who's next? Thank you.
Good evening. Stephen, Steph, Bushman, Buschmann, 1648 Leon Drive.
I'm inclined to grant party status. Ms. Von Spreckelson, you want to note an objection for the record?
I would. That's 3 people at the same address. Is that?
There's no limitation on people in the house, so you have party status, Mr. Bushman. Who's next, please?
Good evening. Nicholas Oropeza.
Oh, boy, Nicholas, hang on. How do you spell it?
Nicholas?
I got that one.
Okay. Oropeza. Oropeza.
Oh, easy. And what's your address?
500 Grapevine Drive.
500 Grapevine. Second. You're on the list. I'm inclined to grant party status. Ms. Von Spreckelson, any objection or questions?
Yes. How are you affected by this application?
My property abuts that property. The egress and ingress is at my house.
Just note my objection for the record.
So noted. You have party status, Nicholas. Thank
Thank you.
you. Yes, ma'am.
Joanne Orpeza, same last name,
Same address, hopefully?
same address.
All
yes.
right.
Joanne, Joanne.
Von Spreckelson, you
Same
want to note your...
objection.
Pardon me?
Same objection.
Okay. You have party status. Thanks, Joanne. Yes, ma'am.
Christine DeLongis, 1608 Leon Drive.
Hang on. Let's spell that last name. I'm sorry. Say again.
DeLongis.
What's your address, please?
1608 Leon Drive.
Don't see on the list of people within 500 feet. Questions, Ms. Von Spreckelson?
Go ahead.
I'm sorry. I didn't want to speak over you. Were you saying something?
I butt up to the property. I'm on the corner of Buckthorn and Leon. I don't understand why I'm not on the list.
You spelled your name with a T, right?
No, D.
Oh,
as
I'm
in
sorry.
Dog.
Oh, good.
DELON.
GIS.
That's me.
Mark and Christine, 1608. I apologize. Sorry for that. Any objection, Ms. Von Spreckelson?
If I may ask, how are you affected differently than other residents within the township?
Well, it does back up to my backyard, and also I'm on what could be considered another egress, because if there's only going to be one egress, I'm on Buckthorn.
You're an adjacent property.
I am an adjacent property, yes.
Okay, great. You have party status. Thank you.
Note my objection, please, for the record.
Objection noted. Yes, ma'am.
Catherine Hillman,
And how do you spell Catherine, K or C?
Eatherini.
Hillman, Hillman?
Correct.
And what's your address?
1567 Pine Tree Drive.
I don't see on my list within 500 feet. Questions, Ms. Von Spreckelson?
How far are you from the property? Is your residence from the property?
There's a street and 3 houses.
And how are you affected by this application differently
I
than
live on the
other?
corner of Pine Tree and Leon Drive. It would be my side yard that all the traffic is going through.
I would object to party status.
Anything from you, Mr. Panzer?
No objection to party status.
Okay. I'm sorry, Ms. Hillman. You can participate as a non-party at the end at public comment.
Because I did get a letter, though.
Yeah, some of the letters went beyond 500 feet, which is why I'm checking this list, but
Okay,
thank you.
Hi, I'm Susan Donahue. I live at 600 Brighton Drive. It's the edge.
Hang on, Susan. 200 Brighton?
600.
600.
Donahue, Donahue. Susan, Susan.
Okay, you are within 500 feet. I'm inclined to grant party status. Ms. Von Spreckelson?
Yes, and how are you affected differently than the other residents in the township?
We would be impacted by traffic greatly. We're right at the corner on Leon.
Corner of Leon and...
Brighton Drive and Leon.
No objection, Mr. Panzer, correct?
Yes,
Okay.
no objection.
Note my objection for the record.
Objection noted. You have party status. Thank you. Who's next?
Christina Westover.
Hang on, Christina. Are you at 1616 Leon Drive?
I am.
Okay.
Westover, Weststover. Christina, Kristina.
Ms. Von Spreckelson.
How far are you from the subject property?
I'm adjacent to the property and also on the corner of Buckthorn, which was a potential egress.
And how are you affected differently than other residents?
It's my backyard.
I object to party status.
Okay. No objection, Mr. Panzer?
No objection.
Okay. You have party status. Thank you, Christina. Yes, sir. What's your name?
Fernando Gomez Salazar.
Hang on. (332) Orvilla Road?
Correct.
Within 500 feet. Julie, any questions?
How far are you from the subject property?
Right next to the property.
Right next to it?
Adjoining, yeah.
And how are you affected differently than other residents within the township?
We will border two houses, two proposed houses, and we might have site access as well.
I object to party status.
Okay, so noted. No objection, Mr. Panzer, correct?
Yes, correct.
Okay, you have party status. Thank you.
Fernando Gomez Salazar.
Yes, ma'am.
Hi, Barbara Kenyon,
Hang on, Barbara.
1574 Leon Drive. I have both of the properties divided in my backyard. Pardon?
Would you spell your last name?
Kenyon.
Thank you.
It's on my list of people within 500 feet. Any questions?
How are you affected differently by this application than other residents?
I have a water problem constantly, always. Marsh.
Objection for the record.
Okay, and no objections, right, Tom?
Correct.
Okay, you have party status, Barbara. Thank you. Yes, sir.
Ignesh Patel,
Could you spell your first name, please?
Jignesh.
Patel. And your address, please?
1582 Leon Drive.
Okay, you're on the list of people within 500 feet. Any questions?
How far is your residence from the subject property?
I'm adjacent property to when the ingress and egress is going to abuse one of my sites is going to be ingress and egress.
And how are you affected differently than the other residents by this application?
Traffic and stormwater.
I object to party status.
Okay, so noted. No objection, right, Tom?
Correct.
Okay, you have party status, Mr. Patel. Thank you. Yes, sir.
Yeah, James Sims, 1627 Leon Drive.
Could you spell your last name for me?
SIMS.
SIMS. Okay, you're on the list of people within 500 feet. Any questions?
How far is your property from the subject property?
Within 500 feet.
And how are you affected differently by this application than the other residents?
My kids play on the street. Neighbors' kids play on the street. Concerned about traffic.
I object to party status.
Okay, your objection's noted for the record. You have party status, James. No objection, right, Tom?
Correct.
All right. Next, please.
Kelly Beaver, Beaver.
Address, Kelly?
1632 Leon Drive.
Okay, she's on the list. Any questions?
How are you affected differently
Well,
by this application than others?
I'm within about 20 feet, and there's a lot of storm drainage issues. My yard backs up to it, and there'll be a lot of traffic concerns.
Object to party status.
Okay, your objection's noted. No objection, right, Tom?
Correct.
Okay, you have party status, Kelly.
No.
You're welcome. Yes, sir.
Hi, Richard Vasso, V as in Victory, ASSO,
Your address, Richard.
1559 Leon Drive.
Okay, he's not on the list. Any questions, Ms. Von Sprickleson?
How far is your property from the subject property?
I'm one house in from the block, from the intersection where the main access point is going to be, so I should be within 500 feet of the property.
How are you affected differently by this application than the other residents?
Being as I live one house in from the block, from the intersection where where the ingress and egress is, I'm going to have all the traffic from that development coming past my house on a daily basis. I'm the neighbor of Miss Barbara Kenyon.
You are within 500 feet. It's Aaron's fault. He pointed me in the wrong direction.
I forgive you.
So I'm inclined to grant him party status. You want to note your objection for the record, Julie?
Yes, please.
Okay, no objections, Tom?
No objection.
Okay, Richard, you have party status.
Thank you.
Uh-huh.
I am Ryan Donahue.
I'm sorry, say again.
Ryan Donahue.
R-Y-A-N?
Yep. I'm at 600 Brighton Drive.
Related to Susan?
Correct.
Okay. He's on the list within 500 feet?
Nope, my objection, same reason.
Okay, your objection's noted. No objection, right, Tom?
Correct.
Okay, you have party status, Ryan.
Thank you.
You're welcome.
Dennis Pollock, 524 Grapevine Drive.
Pollock, P-O-L-L?
L-O-C-K.
Okay, he's on the list within 500 feet. Any questions, Julie?
Yes, how are you affected differently by this application than the other residents?
I'm right where the traffic, I'm at the entrance to the development.
I object to party status.
Okay, your objection's noted. No objection, right, Tom?
No objection.
All right, Dennis, you have party status. Thank you.
Judith Stimson, S-T-I-M as in Mary, S-O-N. I'm at 1635 Leon Drive.
Okay, she's within 500 feet.
And how are you affected differently by this application than the
We
other
are
residents?
located at the corner of Brighton Drive and Leon Drive. There would be a great increase in traffic.
Object to party status.
Okay, your objection's noted. No objection, right, Tom?
Objection.
All right, Judith, you have party status.
Ivna Sibley, IVNA.
Hang on. Start again. You weren't right at the mic for me. First name?
Ivna, IVNA.
I-D-N-A?
Last name Sibley, S-I-B-L-E-Y.
And what's your address?
1534 Leon Drive.
Okay, she's on the list of people within 500 feet. Any questions, Julie?
Yes, how are you affected differently by this application than the other residents?
My house is constantly affected by the water, drainage issues that floods the whole street and my entire yard and side yard.
I object to party status.
Okay, your objection's noted. No objections, right, Tom?
No objection.
Okay. You have party status, Idna. Thank you.
James Castle.
C-A-S-T-L-E?
No, C-A-S-S-E-L.
Oh, goodness. I thought that was easy. Castle.
524 West Arvilla.
Okay, he's on the list of people within 500 feet. Any questions, Julie?
Yes, how are you affected differently by this
I have
application?
drainage that crosses my property from the fields, goes to an underground pipe under Leon Drive. And I also have a lot of wildlife. I got 1.86 acres, and we got a big woods there with a lot of owls, hawks.
Okay. You want to object? All right, your objection's noted. No objection, right, Tom?
No objection.
All right, James, you have party status. Thanks.
My name's Deborah Kimball, D-E-B-O-R-A-H, K-I-M-B-A-L-L. I live at 1551 Leon Drive.
Okay, you're within 500 feet. Questions, Julie?
How are you affected differently by this application than the other residents?
I'll be affected by the approximately 160 cars going by my house every day, which will reduce the value of my house and the increased traffic and the danger to the kids on my street.
Nope, my objection.
Your objection's noted. No objection, right, Tom?
Objection.
Okay, Deborah, you have party status. Yes, sir.
Evening. Chris Schwarz, SCHWARZ, 1566 Leon Drive.
Okay, he's within 500 feet. Any questions?
Same question. How are you affected differently by this application?
Number one would be the traffic, and number two, the stormwater management.
Okay.
Object to party status.
Okay, your objection's noted. No objection, right, Tom? Okay, Chris, you have party status. Yes, sir.
Thomas Nell, Knell.
Hey,
Knell.
and your address, Thomas.
1543 Edgefield, or
What is it again?
1543 Leon Drive.
Leon Drive. He's on it? Okay, he's within 500 feet.
Question. How are you affected differently by this application?
My kids play in the street, and all of the traffic will my value of my house.
Okay, your objection's noted. No objection, right, Tom?
No objection.
Okay, Thomas, you have party status. Yes, sir.
Yes. Dale Foster, 1503 Leon Drive.
What's your first name?
Dale, D-A-L-E. $1503. God bless you.
$54 or Villa is on my sheet.
Dale, D-A-L-E, Foster, F-O-S-T-E-R, 1503
Okay,
Leon.
then you're not within 500 feet. Any questions, Julie?
Yes, how far is your property from the subject property?
A little more than 500 feet.
Okay, and how are you affected differently by this application than the other residents?
The amount of traffic that's going to be coming through Leon Drive and from Ora Villa with my children playing in the street and then all the other children that ride bikes in the street, I think it's going to be a major safety issue.
I object to party status.
Okay, I'm inclined not to grant party status. Tom, you have anything to say or questions to ask?
Thank you.
Okay, sorry, Dale. You can make public comment at the end.
Sure, thanks.
Okay, sure. Anyone else? Last chance? Okay. Now the fun begins. Julie, the case is yours. You go first.
All right, I need a minute. I need to hand out exhibit booklets.
Okay, great. Do you have anything you want to project on the screen?
We did provide a flash drive to...
Okay. If at any time you need a handheld mic, I can give you that if you need to move around.
Probably.
I have a couple.
Party status? What are you doing?
Give party status? Gentleman behind me. Okay. Okay. Yeah, I'm just hearing some noise.
Okay. All right. If one more thing, if anybody does want to have a conversation during the hearing, I ask that you step out. I have to hear everything. I have to take notes. My job is to protect the record, and I'm really vigilant about that. So If you could please cooperate, that would be awesome. Thank you. Go ahead, and be sure to lean into the mic, Julie.
Yes, good evening. Again, Julie Von Spreckelson from the law firm of Eastburn and Gray, here tonight on behalf of the applicant, Pulte Homes of PA Limited Partnership, which is the equitable owner of the property located at 336 Orvilla Road, tax parcel number 35-00-07369-00-3. The legal owners of the property are Robert Pallo, having an 18.75% tenant in common interest, Michelle Pallo, having an 18.75% tenant in common interest, Stephanie K. Beach, having a 12.5% tenant in common interest, Richard E. Beach, having a 12.5% tenant in common interest, Stephanie M. Beach, having a 12.5% tenant in common interest, R. Adam Beach, having a 12.5% tenant in common interest, and Marianne H. Beach, having a 12.5% tenant in common interest. The property is approximately 42.186 acres, and it is located in the township's RA1 residential district. If you want to put the existing conditions, it should be the first slide there. Thank you. So the property, as I mentioned, is in the RA1 district. It's currently has farm fields and some wooded area with, as you can see on the western property line boundary, there's a water course running through the property. There are no structures on the property.
Julie, I'm sorry to interrupt. I just want the record to reflect that something's on the screen and we're all looking at it. Is it in this exhibit booklet as well?
It is, and I was going to run through the exhibit booklet after I just give a brief overview.
Okay, fine, thank you.
And it'll be referred to again by our witnesses.
Yeah. At what point would it be appropriate to raise a potential objection?
To what, Tom?
It would be regarding standing, and only in that the deed submitted with the application was probably 1/10 of what was submitted tonight and did not reflect, in my opinion, adequate standing. The many documents that are provided and will likely be moved, as applicant's Exhibit 1, I would presume, likely tie all the pieces together, but I don't have time to digest those 50, 60 some odd pages as we speak, and so I'd just like to have the objection on the record. I'm sure Ms. Von Spreckelson can clear it up, or the documents will speak for themselves and clear it up.
Okay.
And I will absolutely do that, but please recall, I did submit the other two deeds to the township via letter about a week afterwards, and it was emailed to both Mr. Bibro and to you, Ms. Pianzio.
And you're saying
and
that everything
that you did receive it, and those two other deeds are in Exhibit A1 of the exhibit booklet.
Okay. Is it your position that what is A1 is everything that's been submitted? There's nothing new here?
Oh, no, there's no.
Okay, I think that's what Mr. Panzer's objection is. So
Okay.
why don't we table that? If there is
That's fine.
a running objection on standing, we'll get to it, but maybe between now and the next hearing, you'll have time to review these and maybe ask questions about that. Understood?
And I'm fine to run through everything, I will.
Okay,
I just
great.
wanted to give a brief overview and some background before we get into all the exhibits.
Very good.
So the applicant is proposing a single-family detached dwelling cluster development permitted by conditional use and consisting of 78 lots with single-family detached dwellings, 2 internal roadways, common open space, buffering, stormwater management facilities, and an 8-foot wide walking trail, among other improvements. As a little bit of background, Pulte acquired its equitable interest in the property in September of 2023. Thereafter, Pulte met with the township staff to discuss the application, introduce the proposed project, and obtain some feedback from township staff, and that was in December of last year. After that, Pulte then invited the neighboring area residents, to a meeting to introduce the project, to obtain some feedback from neighboring residents with regard to the proposed use. And that meeting was held on February 5th at Pulte's abutting Del Webb development. And based on some of the resident feedback. Pulte amended its concept plan. It originally had a concept plan. They amended that to increase the setback from the neighboring properties located on Leon Drive to 50 feet. And thereafter, after making additional revisions to the plan, then Pulte then did submit their conditional use application on March 5th. And just very briefly, I want to touch on, and I know your solicitor, as you heard earlier, is very well versed in conditional use law, as is Mr. Panzer. And she did give you a brief overview of some of the key provisions. The first one being that conditional use involves the use of the property. It does not involve the particular details of design of the development. So land development issues, as she mentioned at the outset, are not relevant to this proceeding. Second, a conditional use is a use that is permitted by right and one to which an applicant is entitled, provided applicant demonstrates compliance with the specific objective criteria of the ordinance. And in this case, the specific objective criteria of the ordinance is found in 282-30 E and F. That's titled Special Requirements for Cluster Developments. So once an applicant demonstrates compliance with the specific objective criteria of the ordinance, a legislative presumption arises that the use is consistent with the public health, safety, and welfare. The burden of proof then shifts to the objectors to rebut this presumption by proving to a high degree of probability that the proposed use will generate adverse impacts not normally generated by this type of use, and that those impacts will pose a substantial threat to the public health, safety, and welfare of the community. And to that end, objectors' evidence cannot be mere speculation, unsubstantiated concerns, personal opinions, or perceptions. So here, once applicant demonstrates compliance with the zoning ordinance criteria in 282-30 E and F, the burden shifts to the objectors to present substantial competent evidence demonstrating a high degree of probability that the proposed single-family detached dwelling cluster development will cause adverse impacts not normally generated by this type of use, and that those impacts will pose a substantial threat to the public health, safety, and welfare. That, I will begin to run through the exhibit booklet that I did just distribute. And since we're talking about the issue of standing that Mr. Panzer raised an objection to, we'll start with Exhibit A1. So Exhibit A1 contains the 3 deeds to 336 Orvilla Road, tax parcel number 35-00-07369-00-3. And as is stated in those 3 deeds, the former owners of 336 Orvilla Road, grantors Stephen Kurtz and Maria Chom Kurtz, conveyed the property in fractional amounts over the course of 12 months and 5 days by deeds dated December 29, 1981, January 4, 1982, and January 3, 1983, to the grantees, Marianne K. Pallo and Marianne K. Pallo, trustee for Robert Pallo, and trustee for Michelle Pallo, Stephanie K. Beach, Richard E. Beach, and Stephanie K. Beach, trustee for Stephanie M. Beach, and trustee for R. Adam Beach, and trustee for Marianne H. Beach. Also in A1 are 5 terminations of trust. So after the beneficiaries of the trust, Robert Pallo, Michelle Pallo, Stephanie M. Beach, R. Adam Beach, and Marianne H. Beach attained the age of majority, the trusts were terminated. The trusts for Stephanie M. Beach and R. Adam Beach were terminated in 2007, and the trusts for Robert Pallo, Michelle Pallo, and Marianne H. Beach were terminated in 2008. Upon termination of the trust interests were by law distributed outright and vested in the former individual beneficiaries of the trust. Again, those 5 trust settlement agreements are contained in Exhibit A1. Additionally, as stated in the appointment of successor trustee and trust settlement agreements for Robert Pallo and Michelle Pallo trustee, Mary Ann K. Pallo passed away on July 20th, 2004, and a successor trustee, William R. Pallo, husband of Mary Ann K. Pallo and father of Robert Pallo and Michelle Pallo, were appointed so the trust could be terminated. After the death of Mary Ann K. Pallo, her fractional interest in the property was eventually conveyed to her children, Robert Pallo and Michelle Pallo, after the death of her husband and the children's father, William R. Pallo. So accordingly, Robert Pallo and Michelle Pallo each have an 18.75 tenant in common interest in the property, and Stephanie K. Beach, Richard E. Beach, Stephanie M. Beach, R. Adam Beach, and Marianne H. Beach each have a 12.5 tenant in common interest in the property. Exhibit A2 is the agreement of sale dated September 25th, 2023 between Robert Pallo, Michelle Pallo, Stephanie K. Beach, Richard E. Beach, Stephanie M. Beach, R. Adam Beach, and Marianne H. Beach as sellers, and Pulte Homes of PA LP as purchaser. And that's again contained in Exhibit A2, and this confirms Pulte's equitable ownership in the property and confers standing to bring this application. Going on to A3. A3 is the curriculum vitae of Chris Pizzinis. He is a professional engineer with Bowler Engineering. A4 is an aerial photograph of existing property conditions prepared by Bowler Engineering and dated April 18, 2024. A5 is a rendered conditional use plan prepared by Bowler Engineering dated March 1, 2024, last revised April 18, 2024. A6 is North Penn Water Authority will serve letter dated March 18, 2024. And A7 are color rendering concepts of proposed single-family detached dwellings. And with that, I would like to call my first witness, Chris Pizzinis.
Before you do that, A2 is a redacted agreement of sale. It's your representation that this is, other than the redacted portion, this is a valid agreement of sale, fully executed and currently valid?
Yes.
Okay. All right. Who are you calling first?
Chris Pizzinis.
All right. Let's have him sworn by the court reporter.
Chris Pizzinis, CHRISPUZINAS.
Chris, what is your profession?
I am a project manager for civil engineering land development.
And are you a licensed civil engineer?
Yes.
And how many years have you been licensed?
9 years.
And is that in Pennsylvania?
Yes.
And what is your educational background?
I went to Drexel.
Let's pause there. I'm familiar with Mr. Pizzinis' credentials. I've seen him sworn in as a witness before as an expert in the field of civil engineering. Is that how you would like to offer him?
That's correct.
Any objection, Tom?
I have no objection to the offer.
Go ahead.
Thank you. Appreciate that. Chris, were you engaged by the applicant relative to this application?
Yes.
And what was the scope of that engagement?
To analyze the township code and come up with a conditional use plan. Also do site visits to look at the existing conditions.
And did you prepare the rendered conditional use plan that stated March 1st, 2024, last revised April 18th, 2024 at Exhibit A5 of the exhibit booklet?
Yes.
And is that signed and sealed by you?
Yes.
Okay, so let's start with the aerial photograph of existing property conditions, which is Exhibit A4. Using this exhibit, would you please provide an overview of the existing site conditions?
So the existing site is an irregular shaped parcel. This larger portion in the north area is approximately 1,490 feet by 659 feet. This smaller leg over here is approximately 975 feet going west to east and 450 feet going north to south. The site is surrounded by single-family residential uses. To the north and east, to the west is the Del Webb active adult community, and to the south is movie lots that are owned primarily by the school district,
And what zoning district is this in?
RA1.
And are there environmental constraints on the property?
There is a stream that runs through the property in the northwest portion.
And does it run the length of the property line?
Yes, it runs the entire length, starting in the northern portion of the property down to the southern property line.
And is there limited access to this property?
Yes, there is access provided from Buckthorn Road and Grapevine Road. There is also a 20-foot wide easement that goes out to Orvilla Road.
And both Buckthorn Drive and Grapevine Drive dead end into the property, is that correct?
Yes.
And is there also sidewalk that runs along those roads that dead end into the subject property?
Yes.
And can you describe, so there's no structures on this property, is that correct?
Correct. It is being farmed. There is some woodland areas, but there is no structures on the property currently.
And is there any stormwater management facilities on this site?
No, there is not.
And the surrounding property that you described, that's zoned RA1 as well, correct?
Correct, except the Del Webb property is not zoned RA1. It is the multifamily elderly zoning.
And that's the property abutting to the west?
Correct, to the northwest.
Okay, let's turn to the conditional use plan, which is Exhibit A5. Thank you. Now, you testified you prepared this exhibit, is that correct?
Yes.
And is a cluster development permitted by conditional use in the RA1 district?
Yes.
And is that in 282-24.F?
Yes.
Okay, so before you address the specific objective criteria and development standards for cluster developments, using this plan, will you please give a brief overview of the proposed development?
The proposed development has a single access to Grapevine Drive, located in the northeast corner of the property. We're proposing 78 single-family units. There is 5 separate areas of open space. There is one located along the northeast corner of the property line, one along the northwest corner, one along the south, and why does this keep? 2 internal to the site. The open space areas contain trails where necessary, and we also have stormwater management basins shown on the plan.
Okay, and the sizes of the lots?
The minimum lots are 12,000 square feet, which would be the lots which are in a row. Corner lots, which have a slightly different configuration, are 14,000 square feet.
And are single-family detached dwellings proposed for each lot?
Yes.
And what are the number of parking spaces?
There is 2 parking spaces provided in the driveway for each lot.
And are there garages?
Yes, there is attached garages.
And you mentioned there are internal roadways, correct? There's 2 internal?
Yes, there is the main access and then a loop road and cul-de-sac.
Okay, and then you mentioned that there's the one access point, correct? Can you go into a little more detail about that access road?
The access road meets up with the existing end of Grapevine Drive. We are providing a 50-foot right-of-way, which matches the existing roadway, and we are also providing sidewalk to connect into the existing sidewalk.
And is there emergency access proposed for this development?
Yes, we have an emergency access proposed on Buckthorn.
And is there adequate utility access roads provided?
Yes, we have access to water and we have access to sewer.
And you said that there are some trails. Can you show us the trail connections, please?
So there's a trail that starts on the edge of the road and runs through the open space, which loops on itself and comes back. There's a trail here internal to the site. There's another trail just to the east in another open space area that comes and loops on itself. And then there's a trail along the southwest property line that starts in the cul-de-sac, runs the whole way of the property, and then comes back to join the sidewalk.
Okay, and you mentioned stormwater management basins, correct?
Correct. We are showing 4 stormwater management basins on this proposed layout.
And have the stormwater management basins been fully designed yet?
They have not.
And is that typical for this stage of the proposed project?
Yes, stormwater management is something that is addressed during the land development approval process.
And during the land development approval process, is that when the specifics and details of the design will be provided at that time?
Yes, that is correct.
And is it a requirement of obtaining land development permits and approvals to demonstrate that stormwater management basins as designed will contain stormwater on the site and account for impervious coverage that would be added to the property?
Yes.
And based on the fact that no stormwater management facilities exist on the property currently, will the proposed stormwater basins mitigate existing runoff conditions?
Yes, they will. As part of any approvals from the township, county, and state for obtaining permits that would be needed for construction, we would have to show that there is no increase in runoff from this property.
And let's turn to the buffering and screening. So the lots along the northern property line have 40-foot rear yards. Is that correct?
That is correct.
And then they have, in addition to the 40-foot rear yards, they have an additional 50 feet of buffer area. Is that correct?
Yes, that is correct.
That would be 90 feet. Is that correct?
Correct, 90 feet from the property line to the start of the building envelope.
And that's to the northern property line for the properties that abut on Leon, correct?
Yes.
And if this was a non-cluster by right single-family dwelling development, what's the required setback of the property line to the north?
There would be no open space required, so the lot line could go up to the existing property line, and then the setback, I believe, is only 35 feet, and accessory structures only have to be 10 feet off the property.
So if this is a by right single-family development, you could put a pool or shed or, you know, any of those structures within 10 feet of the properties on Leon. Is that correct?
Well, objection, because it's not. They're asking for a cluster, which is high density.
That's cross-examination question, and number one, that's not what I said. I said if this was a by right. It's not a basis for an objection.
What's your basis, Tom?
Objection is relevance. They're not asking for a single-family by right plan, they're asking for a cluster.
Give her a little latitude. Go ahead. Overruled.
So did you hear my question? Do you want me to repeat it, or?
The answer is yes.
Can I interrupt for 1 second? The plan in this book has a revision date. It's different than the plan that was submitted with your conditional use application, so this has been updated?
Correct.
Okay, and you're going to go through the changes from what you submitted with your application and what you're presenting tonight?
Yeah, and if I can, there were no changes made to the plan. There was some additional detail added to the plan, and that's a big difference. And it was also rendered, so it is colored. You can notice that it is colored, and then there was some additional detail added.
Okay.
Nothing was changed.
All right, but you'll go through what that detail that was added is, right?
Could certainly ask Chris. Chris, Do you
Yeah.
want to run through?
Well, that's
for
the
them?
confusion we're having up here. We have the plan that was submitted, and now we have this plan.
Sure.
Okay, great.
The details that were added, we added the note to the plan about the common open space not being sold separately. We added the trails to be shown more clearly in the open space areas. We added the corner lot detail so it was clear that we were meeting all the zoning requirements for setbacks and lot area for that. And those were the only changes to the plan.
And you did mention that if this was a non-cluster by right single family, that dwelling development, that no common open space is required, correct?
Correct.
Okay, let's turn to the specific objective criteria for cluster developments found in sections 282, 30E, and F of the zoning ordinance. And those are the specific objective conditional use criteria and development standards for the cluster development, correct?
Yes.
And does the proposed cluster development comply with all the requirements of sections 282, 30E, and F of the zoning ordinance?
Yes.
And is the compliance demonstrated on the conditional use plan?
Yes, other than the public water and sewer, we do not show utility connections on this plan.
Okay. Let's run through each requirement and describe how the cluster development complies, and start with 282-30E1.
Okay. You want me to read each individual one and then?
Sure.
Okay.
That would probably be the easiest way to do it.
E1, the tract of land to be developed shall be a minimum of 10 acres in gross area and shall be held in a single and separate ownership. The gross area of the lot is approximately 42.168 acres. Meet that criteria. The planned cluster development shall be serviced by public water and public sewer acceptable to the Board of Commissioners and subject to the approval of the Pennsylvania Department of Environmental Protection and any applicable local authority. We have a will serve letter from North Penn Water Authority. We have also been in contact with...
I'm sorry, is that in A6 of the exhibit booklet?
Yes, that is A6 of the exhibit booklet. And we are also aware that there is public sewer in Orville Road that we do have access to. So
And that access is the easement, 20-foot wide easement that you referenced earlier tonight, correct?
Correct. E3, not less than 15% of the total developable area of a tract and all non-developable areas shall be preserved as common open space in accordance with the provision of 282-30F. We are providing 18% open space, and that open space does not include any of the stormwater management basins or the stream and associated buffer.
Okay, let's move on to subsection F.
F1, use regulations in a cluster development, single-family detached residential dwellings, open space, and recreational areas and structures shall be permitted. That is what we have proposed on this plan. F2, density, the number of dwelling units shall not exceed 2.2 dwelling units per developable acre over the developable area of the entire tract, including that portion of the tract to be permanently reserved in common open space. This limitation shall in all cases govern density except as modified by subsection F7 below. We are proposing 2 dwelling units per acre and meet this requirement. Lot area. A lot area of not less than 12,000 square feet shall be provided for every dwelling. Undevelopable land shall not be counted when calculated in the minimum lot area, although such undevelopable land may be included within the individual lots, only as determined by the Board of Commissioners. As shown on the details on the conditional use plan that's rendered, Exhibit A5, we have a typical lot detail for the smallest lots, which shows a minimum lot area of 12,000 square feet. F4, minimum lot width. A lot width of not less than 80 feet at the building line shall be provided for every dwelling. Again, shown on the typical lot detail, we meet that requirement and have 80 feet as the lot width. F5, yard regulations, front yard. There should be a front yard on each lot, which shall not be less than 35 feet in depth. We meet that requirement. And also for the corner lots, they have 2 front yards, and we meet that requirement as shown on the typical corner lot detail. For side yards, there should be 2 side yards on each lot, neither of which shall be less than 10 feet in width and having an aggregate width of 30 feet. We are showing 15 feet on each side of the lot. 5B2 is for corner lots. We have the detail that requires 2 front yards, a rear yard, and a side yard. And the corner lot detail shows compliance with that. Rear yards, there shall be a rear yard on each lot, which shall not be less than 40 feet in depth. We're showing that on the lot details. An accessory use structure, if entirely separate from the main building and located at least 10 feet further back than the rear of the main building, may be erected in the rear yard, but shall not be located within 10 feet of the rear or side property line. We are not showing any accessory structures on this plan. If any were to be added, they would need to comply with that.
And the Leon Drive properties, the properties that would abut Leon Drive, the rear yards are 50 feet, correct?
The distance from the existing property line to the individual lots is 50 feet.
Correct, the open space area.
The open space area, and then there's an additional 40-foot rear yard setback to that. F6 is regarding coverage regulations. Building coverage shall not exceed 25%. Impervious coverage shall not exceed 35%. We're showing that we would meet those requirements. F7 and F8 have to deal with historical and cultural resources that do not apply to this development.
Okay. So let's move on and talk about the regulations for common open space that are in subsection G. And the first one states, is there a note on the plan that says the common open space shall not be separately sold and shall not be further developed or subdivided?
Yes, that is correct.
Subsection 1B states, is the common open space designed as a continuous system of open space, and is it connected with open space areas on abutting parcels whenever possible?
I can elaborate on that. So there is, majority of the site is not surrounded by open space because it is developed with single-family residential lots. So the open space areas that we have, again, to the northeast was to help provide additional separation. Along the southwest and western areas, there is a plot of township-owned land. So we have this designated as open space on the western side that does connect with township land. And then we added the trails, which also connect to sidewalks, to have connectivity between all the open space areas in the proposed development.
And subsection 1C, does the common open space area have safe and convenient access to the residentially developed area, the tract by adjoining frontage on streets or easements capable of accommodating pedestrian, bicycle, and maintenance vehicle traffic?
It does, and that's why we also provided the trail connectivity going out to the sidewalks within the right-of-way.
And subsection 1D, is the common open space comprised of a minimum 10,000 square feet in area and not less than 75 feet in width except for trails and trail linkages?
Yes.
And can you describe that?
Yeah.
A little more detail.
So there's 5 total open space areas that was discussed. This open space area along the northeast corner is 61,942 square feet approximately. The interior open space area on the east side of the property is 23,958 square feet. The open space area that runs along the southern property line that stops at the stream buffer is approximately 6,000 64,033 square feet. The portion of open space on the west side of the stream is 106,112 square feet, and the interior open space is 57,237 square feet. Areas where it is less than 75 feet, like along the northeast property line, we have
75 feet in width.
75 feet in width. Where this is 50, we have provided a trail to meet that requirement.
Okay, subsection 1E, is the common open space physically delineated from adjoining private lands using berms, fencing, or other means?
The open space would be separated by some of the existing vegetation, and then there would also be a 10-foot landscape buffer, which could provide some of those amenities. We would have to evaluate the use of berms during land development when looking at topography and effects on adjacent properties.
And fencing is also possible?
Correct.
Subsection 1F, does the common open space area predominantly consist of natural environmental features or planted and maintained vegetation?
Yes, it would.
Does the common open space area contain walking, biking, or equestrian trails,
Yes.
as you already previously discussed?
Correct.
Subsection 1G states that the common open space shall be configured so as to be acceptable to the Board of Commissioners. Correct?
Yes.
Okay, so subsection 2 then discusses ownership and maintenance of the common open space. And subsection A, 2A, states that the developer shall offer the common open space for dedication for public use if required by the township.
Correct.
And the subsection, is the common open space being offered for dedication to the township?
Yes, it will be.
And B states that upon permission of the township, the developer may transfer the fee simple title and the common open space to a private nonprofit organization, correct?
Yes.
And then finally, subsection 3 states that if the township does not accept dedication and there is no transfer to a private nonprofit organization, the developer shall provide for ownership and maintenance of the common open space by an HOA and in accordance with the Pennsylvania Uniform Condominium Act, and then provides requirements for the creation of the HOA. So if the township does not accept dedication of the open space area, will that be owned and maintained by an HOA?
Yes.
Okay. If we could turn to A7. And does A7 of the exhibit booklet contain concept renderings of the proposed single-family detached dwellings?
Yes.
Describe them, and there's three renderings up there.
So yeah, I'll just flip through all three. The houses are going to be two-story houses that contain a basement and an attached garage, and they will be plus or minus 3,000 square feet depending on what options are picked.
Chris, in your professional opinion as an expert in civil engineering, will the establishment, maintenance, or operation of the single-family detached dwelling cluster development in any manner be detrimental to or endanger the public health, safety, or welfare in a manner not usually generated by this use?
No, this use is in character with the surrounding uses of single-family homes.
And the use also meets the conditional use criteria, correct?
Correct.
And in your professional opinion as an expert in civil engineering, will this single-family detached dwelling cluster development be injurious to the use and enjoyment of properties in the immediate vicinity or impede the normal and orderly development or improvement of the surrounding property?
No, it will not. With the roads being stubbed out, Grapevine and Buckthorn, it seems that it was always contemplated that there would be some kind of development here, and it's single family, which again is in character with the rest of the area.
And is there significant buffer and common open space area being provided as well?
Yes.
And walking trails, correct?
Yes.
That's all I have of this witness.
Hanser.
So there's been much discussion about the buffer to the north, not 75 feet wide, it's 50 feet wide, correct?
Correct.
You justify that by saying you're going to run a trail through the 50-foot.
Correct.
Pull the mic closer to you, Tom.
If you don't have a trail, then you understand that the requirement is 75 feet in buffer.
Correct.
You also talked about the depth of the rear yards along the homes that are on Leon Drive, on your properties being 40 feet. So buffer and then 40 feet of rear yard.
Correct, yes.
And that's a requirement of the ordinance
Yes.
or cluster.
Yes. Well, the location of the open space is not designated by the ordinance. So we would not necessarily have to put it at that location. We are putting it there to provide additional buffering from those houses.
With a walking trail,
Correct.
not 75 feet.
Correct.
The 40 feet is what I was referring to as.
Yes.
Having a hard time hearing you, Tom.
You talked about the requirement for water and sewer access. The letter at A7 is from, A6 is from the North Penn Water Authority, yes?
Yes.
You do not have a unqualified will serve letter from the local sewer authority.
We do not yet. We have been in communication with them on getting that. We just have not received it at this time.
And is it your understanding that at this point, they are representing that they do not have adequate capacity for a 78-unit residential dwelling?
Objection.
Is that the discussion you're having?
Overruled. You can answer.
The discussion that we've had is that they are trying to determine if they have capacity depending on where the connection point may be.
And thus far, they've represented that they don't have unqualified capacity for the 78 units proposed. Is that correct?
They represented they did not have capacity in Leon Drive.
And that's all you've heard?
That's all I've heard.
You've provided, designed one access point to the 78 unit development, yes?
Correct.
And that comes in off of Grapevine Drive.
Correct.
Buckthorn has a stub street, yes?
It does.
And you've proposed no access from Buckthorn.
Correct.
Have you reviewed with the fire marshal his opinion regarding health, safety, and welfare for a one point of access for 78-unit residential subdivision?
We have not gotten any feedback from the fire marshal.
Well, you've asked.
We did not specifically submit anything to him.
The 2 points on the plan where you've indicated site access, and it looks like a portion of the open space, for instance, from Buckthorn to the proposed Road B, is that your proposed emergency access point?
Yes, it is.
And on this plan, the access point from the emergency access that you're proposing from Buckthorn to proposed Road B is also reflected and calculated in your open space calculations.
It is. We would anticipate it to be a grass paved system.
And so you're suggesting that it would be shared between community open space and emergency access?
Yes.
And the same would go for the emergency access point off the cul-de-sac to the southeastern aspect of the parcel?
Yes.
And it looks like that buffer between the southern side and the property to the south is also 50 feet wide, as opposed to 75?
I believe that buffer's 30 feet.
30 feet instead of 75? Yes?
Correct.
And you're proposing to put an 8-foot wide walking trail on that 30-foot buffer, is that right?
Yes.
Okay. And the placement of the walking trail, in your opinion, justifies the reduction of the buffer from 75 to 30?
Correct.
The ordinance speaks in terms of keeping the open space contiguous. It appears that the open space in question is in fact not contiguous. It's on the corners, the perimeter, and 2 spots in the middle. Is that how you designed it?
That is the layout that we have, and we have provided the trails connecting to the sidewalk to allow for access to all of the open space.
So, the ordinance speaks in terms of developable and undevelopable area. The plan as submitted had gross site area at 42.186 acres and developable area at 39.275 acres, yes?
Yes.
And is that the same calculation you used on the plan you submitted tonight?
Yes.
And what is the difference, that is, what were the calculations to take you from gross to developable?
The natural feature of the stream with the associated assumed 50-foot floodway is the area that is excluded from the gross lot area to come up with the developable area.
And so is that calculation contained on the plan somewhere?
No, it is not.
And were there any other reductions from gross for undevelopable site area?
None that we identified.
So you didn't find any overhead utility lines,
No.
easements?
No.
Did you do a wetland study of any sort?
We looked at the National Wetland Inventory online, which only indicated the stream on the property.
And so that report or that study would have shown alluvial soils?
The National Wetland Inventory does not include soils.
Did you have any indication that there are alluvial soils on site?
No.
Did you do any kind of study to determine whether there were alluvial soils on site?
Objections, not relevant.
Overruled.
We did not at this time.
Did you consider the stream land covered by water?
Yes.
And was there any other area of the property that was land covered by water?
Not that was seen during the survey or indicated by mapping that we looked at.
And in order to calculate the undevelopable land, in your opinion, using the stream in question, you took what as a measurement? How did you arrive at your calculations?
The top of bank and then an assumed 50-foot floodway, which is what the state regulates on unmapped streams.
And what about the length north to south and that it's not a direct line?
The offset is just taken from the top of the bank of the stream.
When I look at the cartways identified on the plan that was submitted with the application, they illustrate a 28-foot cartway for all roadways within the proposed development. Is that accurate?
Yes.
And do you realize that the ordinance requires a 34-foot cartway?
That is the subdivision and land development ordinance.
So the
No,
south,
objection. It's not a land development proceeding.
Question. Next question, Tom.
so if the cartway is 34 feet instead of 28 feet, would that reduce, would that change the calculations for lot area, impervious surface, or open space?
I'm going to object. He is referring to a subdivision and land development ordinance as stated at the beginning of this hearing. That's not relevant.
Well, the question is whether or not it would affect the lot size and the calculations, so therefore, I think it is relevant. Overruled.
There's a lot of factors that go into that. So I can't say whether it would affect the number of lots or the configuration if the cartways were increased from 28 to 34.
The plan submitted with the application reflects what I believe is sidewalk on one side of the road for the proposed road. Did you reflect sidewalk on each side of the road or just one side?
Sidewalk is proposed on one side of the road.
And while you have proposed stormwater management basins within the open space, you indicate that you have not included the size of the basin, the area of the basin, in your calculation of the required open space. Is that accurate?
Yes.
And just to be clear, the undevelopable land is the difference between the minimum, the minimum tract area, or the tract area on your plan, 42 acres and change, less the developable area, which is the 39.275 acres. Is that accurate?
Yes.
You would agree with regard to density that if your developable area is reduced, your density as proposed will increase?
Correct.
Using your calculations, you're at density of 2.0 and 2.2 is permitted, correct?
Correct.
Talked about the landscape separation between the open space and abutting properties. It's not yet designed, is that correct?
Correct.
And you have no elevations prepared, is that accurate?
Correct.
I take it you defer all traffic to another professional?
Yes.
You do propose a cul-de-sac on the southeast corner of the proposed development, yes?
Yes.
And the bulb of the cul-de-sac is at the terminus of the loop road that starts at proposed A to the north, wraps all the way around, and goes to the southeast corner, yeah?
Yes.
When you discussed proposed common open space, you pointed to an area to the west side of the lot, right?
Yes.
And from the rendering, it appears that that is a heavily wooded area?
Correct.
So the proposal is to leave existing wooded area to the west of the existing stream as part of the required common open space. Is that correct?
Yes.
Those are all the questions I have of this witness at this time.
All right, I'm going to propose we take a 5-minute comfort break. We'll come right back. Okay, everybody in their places? Oh, wait, I don't see Tom. Tom's there. Okay, we're going to, the Board of Commissioners is going to have the ability to ask questions, and then those who got party status can ask questions, so we'll start with the board. Who would like to go first? Any questions from the Board of Commissioners?
All right, I'm going to start off, and then we have a number of other commissioners, I believe, who also have questions. Hi, my name is Tom Zipfel. I'm president of the board, Hatfield Township, obviously. But I have a handful of questions that I want to ask for clarification.
Okay.
You talked about sidewalks in your testimony. Am I correct? Did you say that this rendering only has sidewalks on one side of the street?
That is correct.
So there will be homes on this street. One side will have a sidewalk, the other one will not.
Correct.
Now, we talked about, you did not include the size of the basin in your calculation for open space, correct?
Correct. Per the ordinance, it's allowed to be within the open space, but not counted towards it.
Okay, but if your basin size changes, that's going to impact your open space calculation, correct?
Yes.
You talked about the municipal authority. You do not have a determination from the municipal authority that tells you that they can provide service for this property, correct?
Correct, not at this time.
Not have, you're not able to tell us where any connections would be as we see tonight, correct?
The connection would go out towards Orvilla Road because we are aware that Leon does not have capacity and there is public sewer available in Orvilla Road.
So that is your expectation, or that is the alternative, because Leon cannot provide sufficient service. That's the alternative, but again, you do not have approval from the municipal authority saying that it can provide that service at that location.
Correct.
And you mentioned earlier, as a part of the statute, I mean, you probably know that as a group, we look at the health, safety, and welfare considerations here, right? You said earlier that health, safety, and welfare is met generally, is that correct?
Yes.
You have not met with our fire marshal to let us know if it meets the code?
We have not.
You are asking us to, you have submitted an application and asked us to approve an application that does not involve a consideration from our fire marshal. Okay, that's fine. No, I follow.
Starting to get like.
Yeah, no, I understand.
Well, can you use your microphone first, Julie? And secondly, the board's allowed to ask questions if you think they're in a form of cross-examination. Maybe they are, but they're questions nonetheless.
Yeah, I'm not worried. He answered my question already. This application does not include a calculation of developable land. I can't say that term. Developable land. Is that correct?
Developable.
Thank you.
There you go.
It does not show the calculation. It just shows the developable area amount.
All right. I may have some follow-up, but I know other commissioners have some questions.
Yeah, sure. Hi, my name is Shahidul Partha. I'm the one of the board commissioner in here. You said like the emergency exit from our villa, right? From the cul-de-sac to our villa?
Correct, one would be provided.
I'm not showing anything in here, this emergency exit, how you will get access from the Orvilla.
There's an existing 20-foot wide easement. That exists along these properties that benefits our property that we can use.
Are you agreed on something like you will use that, it get permitted, or how you will use that? Do you own the property? Like how you access the 20 feet, how you will access
It's an existing easement on that lot that benefits our lot.
I think his question is, are there any rules about the easement?
It
Is it
is,
an easement for anything, or is it specifically for emergency access and/or sewer? Because you mentioned running sewer through it.
there's no restrictions on the use of that easement, is our understanding.
Follow-up question to that, Jerry Andrews. Follow-up question would be, will that be constructed in such a way to support an emergency vehicle, or you just identified it as potential emergency access?
Yes, as with other developments that have emergency access, the access way would be designed in accordance with the fire marshal and whatever material he would like. Grass paved system is generally acceptable and shown to take loads of fire emergency vehicles.
And a couple questions for myself. Is this development going to be an HOA?
Yes, there will be an HOA.
Is that a public trail system you're installing, or is that for the community?
It would be offered for dedication to the public first.
Township chooses not to take it, then it wouldn't be public.
I'm not sure of the details, how that would be worked out with the HOA and public access.
You mentioned 2 parking spots per house. I don't see a spot where a visitor would park their car.
There is both the attached garage and the driveway can accommodate 2 vehicles.
So there's no parking on the street then?
The cartway with coordination with the fire marshal could be acceptable to have parking on one side of the street.
Specifically, there's not a dedicated parking spot for 79 homes. They might have a couple might have a party one time. If you have 30 cars coming in, haphazard an approach where they park?
No, there's not dedicated overflow parking.
And so why Grapevine and not, Hawthorne or Buckman? Buckthorn Road? Why'd you choose Grapevine and not Buckthorn or both? Access or?
I would defer access questions to the traffic engineer on the number of accesses provided.
It wasn't considered to move the access point to the other location and?
In coming up with this plan, we looked at multiple iterations of using both access points and each one individually and felt that this layout and connection worked the best.
And I think that this clarification, you're suggesting that the trails connecting the open space provides a contiguous open space. Is that correct?
Correct.
I just have a quick follow-up before I forget it. As a part of the application, do you have a wetland scientist study? I'm not sure the exact terminology for it, but it's a wetland study.
We only looked at the National Wetlands Inventory maps available online.
That's a no.
Correct.
Yeah, I'm going to assume that's a no. There's a stream that I think you testified that it kind of comes in from the north down to the south west of the property, right?
Correct.
Okay. normally with, and it's a steady, it's not a broken stream, it's a consistent stream from that one, the starting point to the end, correct? It goes all the way through the property?
Correct.
Okay. And with that, so normally there is some kind of wetland considerations when you have a stream that runs through a property, is that right?
A stream doesn't necessarily mean that there is wetlands associated, as wetlands have specific criteria for soil and plant material.
The wetland study would tell us that.
Yes.
Hold on, were you intending to do wetland study? Development?
One would have to be completed. Normally, we would do that during land development.
Or to be completed, and it was then.
Gary, I need you to get closer to the mic.
If you identified wetlands, that percentage of space or that volume of space would be removed from your open space calculations at that point?
If the wetlands exceeded the area that's already set aside, which is 50 feet from the top of bank.
All right, great, thank you.
I have a, Bob Rogers. I have a question about, so the properties to the north and basically to the south, are those deeds going to be restricted because of the open space there? I know typically that's not done. People have a way of encroaching on.
The open space would be its own separate parcel.
Would there be a restricted deed making sure that no one could develop that property whatsoever? All those homes?
Yeah, that's part of the open space requirement, is that it can't be further subdivided or developed.
Yeah, I mean, nobody can put a shed on it, that kind of stuff. I mean.
Correct, yeah.
Anybody? Yeah, the other question is, so you're proposing 28-foot roads, wide cartways roads. That's not, that doesn't really fit in with the ordinance, correct?
Could you clarify what ordinance you're speaking of?
Oh, the width of the roads.
Right, what ordinance are you referring to? You said it doesn't comply with the ordinance.
Our basic requirements are for roads.
Well, this is conditional use application, so it complies with the zoning ordinance requirements.
So is there an objection, or are you answering the question?
I'm sorry, I was trying to clarify.
So I think the question is, does the 28-foot wide cartway comply with the ordinance? And maybe your witness can answer it in a way that clarifies what you're trying to clarify.
Well, if we know what ordinance, then he can answer. I don't know if it's just a general ordinance.
Well, let's ask it this way, Chris. Which ordinance requires the cartway of the road?
The subdivision and land development ordinance.
So when Commissioner Rogers asked you a question, the 28-foot wide cartway doesn't comply with the ordinance, it would be the subdivision and land development ordinance, correct?
Correct.
And
that's when I would object to it, because it's subdivision land development ordinance requirement.
I think where Mr. Rogers is going is that in the event, so you would require a waiver during the subdivision and land development process in order to have a 28-foot wide cartway width, because the requirement's 34, correct?
When we get to land development, I think we would then determine that.
Well, let's see if Chris can answer the question. Chris, would a waiver be required?
For the current layout, yes, a waiver would be required. We are providing the 50 feet of right-of-way, which is required per the subdivision and land development ordinance, allowing us to make modifications to the roadway cartway width without impacting the layout.
Okay. And I think, Mr. Rogers, where you're going was, in the event a waiver is not granted, it would affect the layout of this plan. Is that fair to say?
Yes.
Okay. Is that your point?
I got a little confused. Earlier you said in the prior testimony that you weren't able to determine whether or not a 28-foot cartway or 28-foot versus 34 would affect the layout. I think you just said it doesn't. So if you were required to go 34 feet cartway, that plan doesn't change the configuration at all? It stays as it is?
Correct. During our break, was just looking at it again to see what impacts that may have, and because the right-of-way is provided, the added cartway could be provided.
right-of-way is provided? I think it said something, there's got to be 30 feet in front of the home?
The right-of-way is 50 feet wide, and that contains the cartway.
Understood, but from the right-of-way to the front of the house, you said there had to be a 35-foot setback, or what was the number?
Yes, that is a 35-foot setback.
So if you pushed it back that 6 feet, the front yard setback is still maintained?
Yes,
Because you're measuring from the ultimate right-of-way
correct.
of 50 feet.
Yes.
So it's just a matter of what you're installing within that 50-foot ultimate right-of-way.
Correct.
Okay.
Does that affect any of your calculations at all?
Not that are shown on this plan.
Fair to say it would affect your impervious coverage and your stormwater management, though, right?
That's what I mean.
That is correct.
Jennifer Lostraco. Chris, did you walk the whole property in person?
I did not walk the entire property in person, no.
What did you see in person?
I only went down Grapevine, and walked in a little bit and just looked around from there.
Yeah.
I have a couple. Did you do any studies about floodplain? Was that part of any of your developable acre calculations?
Yes, so that was where we identified that the stream is unmapped, so there is no floodplain determined from FEMA. However, with state regulations, there's a 50-foot floodway associated with any unnamed or unmapped tributary, which is what's shown on the plan.
And my second question is, the open space that's behind the houses, will it be demarked in any way so people would know where their backyard ends and the open space begins? Will it be fenced, or will everyone just consider that their backyard?
We don't have anything proposed at this time to demarc that area separately.
Okay, thank you. Anything else from the board? Anybody else have something while Jerry's thinking?
Gary's thinking, I'll look.
I know what it was.
Okay, stay close to the mic though, Jerry.
All right. So from walking the lot, you went as far as Grapevine and a few feet in. And so no one else walked the rest of the lot to understand precisely what's in there? We just went by maps and aerials and things of that nature?
The survey crew that did the existing condition survey covered the entire property.
But they weren't providing feedback for storms, wetlands, or anything of that nature. They were just surveying to get the property lines. They didn't provide feedback to you of what they saw, observed, other than surveying the property.
They surveyed tree lines, property lines, the stream location with top of bank.
How about topography?
There was no topography surveyed.
Thank you.
Anybody else? Okay, now it's time for parties. If you're a party and you'd like to ask questions of this witness and it has to do with the testimony that he provided, now is the time. You can line up so that we can be efficient and move through one to the other. You don't have to ask questions, but if you have them, now is the time. Start with your name.
Hi, I'm Christy Westover. I'm on that corner of Leon and Buckthorn. I was wondering about the walkway that would be between in that space between the homes. You said if the walkway is not picked up by Hatfield, then it would be part of the properties. Would that mean that the current residents would not have access to that walkway behind our houses?
You're talking about the trail, right? When
Yeah,
you say
the
walkway?
trail.
Okay.
That would be up to when the HOA is formed, and if the township didn't take it, what rights for access would possibly be given or granted.
Oh, so we may not have access to the trail behind our house. Thanks.
Hi, Donna Bushman. So I have 3 questions that pertain to unique problems with conditional uses. My topic, I have a topic. It's traffic.
So Donna, I'm going to help you here.
Okay,
So it
thanks.
has to be a question. So if I feel like you're getting ahead and I don't feel that question mark coming, I'm going to stop you and have you try to formulate it. Think Jeopardy. Think of how do I ask this in the form of a question, okay?
So, question number one, was there a traffic study done?
Going to object. It's not in this witness's knowledge. He's not a traffic engineer.
The question is, do you know, Chris, if a traffic study was done?
I'm not aware to the extent that traffic was looked at. I know that there was some studies done.
Anything else, Donna? Anything else? Okay. Anybody else have questions? Your name, ma'am?
Christine DeLongis.
Christine, what's your last name?
D-E-L-O-N-G-I-S. D as in dog is the first one.
Got it. And you're a party, right, Christine?
I am a party.
Okay, go ahead. What's your question?
So my first question is, if you were to put a walkway behind our house, there's currently trees there. Will those trees have to be removed to put the walkway there?
We would have to evaluate the topography in that area as to where the walkway would ultimately land. We have 50 feet of open space to place the walkway. The requirement from the code is that we're providing berming and screening, so we would evaluate all of those items during the land development process to show the complete design.
So there's a potential we could lose the trees behind my house, correct?
We would not be able to remove trees that are on your property.
Right, but you can remove them from the open space area.
Correct.
For the continuous open space plan, you don't have a continuous open space plan. You have 5 separate open spaces in your plan, correct?
Correct.
All right, one more, let me think. And for the open space, you have no provided parking for anyone to use that open space, to come in and use it. There's no parking for those people to come and use the open space.
There is no demarked parking on the roadways, with the cartway width. Parking on one side of the street would most likely be acceptable.
Okay, so my question is, in one of the items where you talk about common space, you did not mention common open space shall contain appropriate access improvements and shall be provided with permitting parking areas as appropriate. Can you tell me why you didn't read that sentence? It wasn't you, Chris, it was when you were reading the... Can you tell me why you didn't read that sentence?
Which sentence? I'm sorry.
I don't have the correct numbers the way you did it, but it's in the common space residential districts shall designate in accordance with the following standards. Mine go 1, 2, 3, but yours had different numbers.
That's G1C. It is common open space shall contain appropriate access improvements and shall be provided with perimeter parking areas as appropriate.
Correct, and I just want to know why that sentence wasn't, you didn't mention that sentence when you were reading this?
Let me help you. Your question is, does the plan meet that criteria?
Correct.
Okay. How about that?
In a development such as this, it would be rather unlikely for people to be driving as a destination to use these trails. However, if they do, as stated, with the cartway widths, it would be acceptable to park on one side of the street.
Anything else, Christine?
No, I think that's it. Thank you.
Question? Am I allowed to ask a question?
Go ahead, Commissioner, sure.
So we're 28 feet as what you've presented, and I have a car that's 8 foot wide. That comes to environmental or safety, right? Health, welfare, and safety. You're asking a truck, if an emergency, drive through 20 feet to access that development?
Yes.
But we haven't asked the fire marshal that question yet. We haven't asked for feedback or input.
This is,
That dialogue hasn't happened yet.
no, but this is typical with other communities within the township.
Thank you.
Yes, sir, what's your name?
Steve Bushman. The trails, is there a designated width of the actual trail itself, and is that counted as impervious?
8 feet wide is what we have denoted on the plan, and it would count as impervious.
Your name, sir?
Fernando Gomez Salazar.
Question, Fernando.
So you said you didn't walk the site yourself, and the actual site survey was just property lines and property trees. So how was it decided that the easement from Orvilla was appropriate for an emergency access?
During the research of the property is when the easement was discovered, and the easement document that allows us to use the 20-foot wide easement that goes out to Orvilla Road.
So you don't know the exact conditions of that easement or access currently?
It's currently being used by the homeowners who live back there on the flag lot.
Right, it's about 450 feet of unpaved
Hang on,
gravel
Fernando.
road.
This is not the time to testify.
Okay.
Questions only.
That's it. That's all I
All
got.
right, great, thank you. Sir,
Good evening. Nicholas Oro-Pisa.
go ahead.
Hey, Chris. So when you spoke that you looked at Grapevine and Buckthorn as possible entry and exit points.
Correct.
Determined that Grapevine was the best. I think that's the words you actually used, the best. When you say it's the best, what do you mean by that? Please elaborate on that.
Based on the layout provided and how we want to have open space with buffering, when we laid it out with the access to Grapevine, it provided what we felt was the best layout on this parcel to accommodate separation from the existing lots.
You're a civil engineer?
Correct.
Did you have 9 years experience?
I've been a licensed PE for 9 years.
Okay. And you're sworn in as an expert tonight?
Correct.
So based on your expertise, do you typically see 78 houses with one entry and exit point into a neighborhood?
Yes.
How often do you see that?
I don't have an exact number.
Thank you. Your name, ma'am?
Joanne Orpeza. A question about what you had asked about the soil. Is that alluvium soil? Is that what that is? We have an answer to that. I'm sorry, I heard you ask something about it. Do you know, Chris?
No, we have not done a soil study.
Oh, so we don't know what that soil is. And then also the walking trail. So you're saying that you only have to provide 50 feet of open space there because you stuck a trail there? Otherwise, it would be 75 feet? Is that what I heard?
Correct.
So if no trails there, and the trail doesn't lead to anywhere, it just loops around. It's basically the same as the sidewalk on the outside?
Correct.
What was your first name again? Joanne, thank you. Sir.
Jignesh Patel. Right, actually, Nicholas stole my question, so I can ask it, but I get...
Did you come up with something else then?
I do have some others.
Okay.
Is the title search did when you guys did the survey of the boundary? Title search or any kind of search binder done to find out there is any more access point to the site?
Yes.
Yes? Okay.
Yeah, a title search was done on the property.
All right. The next question is, you always, like when you were going over, you always say it's 90 feet from the back of the house, from the Leon Drive, right?
It's, the building envelope setback is 90 feet from the existing property line.
50-foot buffer and a 40-foot setback, rear
Cor-
setback line.
Correct.
Look at the northeast corner. You see the 90-foot setback there, or 90-foot buffer there?
No, Lot 1 does not have that same setback.
All right, last question. You say when you're putting trails or something, you're gonna cut down the tree if needed or something. I don't know any kind of law, but is open space permit to cut down the trees?
Your question is, are they allowed to cut down trees?
Trees in open space.
In open space,
Yes.
okay.
Well, I would object that it's land development question.
It's relevant. You're talking about open space and trails. Someone else brought up the trees. He answered that question. You might not know the answer to the question, but the question's for you, Chris. Are you allowed to cut down trees in open space?
Yes.
Okay, all right. Thank you.
Huh?
Follow-up question. Yeah, so that corner property does not satisfy the 90-foot setback requirement? So is the expectation a waiver is going to be applied for during the...
There is no 90-foot setback requirement. That's just what we are providing.
Got it, okay.
And that's Lot 1, right?
Correct,
Okay.
Lot 1.
All right.
Since we're on that, are there any other lots that don't have the 90-foot setback other than Lot 1?
There are several other lots that do not have a building envelope setback that is 90 feet from the property.
Which ones are they? And I'm assuming that they're probably near the cul-de-sac.
They would,
I'm sorry, I was just confused by the question,
Yeah,
because
I'm
when
sorry.
we referenced the
which ones-
90-foot...
Which ones are they? Which ones do not have a 90-foot setback like the others that you testified about?
When we testified, just so we can clarify the testimony was along Leon Drive is
Okay.
where that's provided.
That's fine. And I'm looking to
So-
find out if
I
where
just
where the
wanted to
others are.
clarify.
Yeah, you're right.
So the answer would be any lot that's not abutting a Leon Drive property does not have that 90-foot setback? Is that the answer?
no, not necessarily. Lots 42,
For laser?
Yeah, which ones?
And use the numbers if you can of
yeah,
the lot
lot
numbers.
42 is right here, going up to lot 48, which would be the first one that is more parallel to the property line along Leon Drive. All of these would have a higher buffer amount due to the open space. Also, lots 9 through 15 in this area would also have something closer to 90 feet.
So there, and I'm sorry if I'm not following, but other than Lot 1, which has something less than 90 feet, right? Let me ask a better question. Lot 1 has less than a 90-foot setback, correct?
Yes.
Okay. What others have less than a 90-foot setback?
Lots 1 through 5.
Okay.
I'm not exactly sure of the transition, but somewhere along lot 15, which is in this area where the property line comes down.
Okay.
And then the remainder of the lots along the southern property line, because they only have 70.
Okay. So that when I say bottom, I mean bottom of the picture that we're looking at. That bottom row approximately has a 70-foot setback across each of the homes there.
The rear yard setback for the building envelope is located 70 feet from the property line.
Okay. I don't have any other questions on that.
Okay. Yes, sir. What's your name?
Rick Vasso?
Rick?
Yeah, Richard Vasso.
Go ahead, Rick.
You had indicated in your testimony that this application meets the requirements of conditional uses, and one of the that you had referenced in 282-205 B3 or B2, excuse me, that the conditional use will not be detrimental to or endanger the public health, safety, morals, comfort, or general welfare. I would like to know what steps have been taken, what have you done to establish that requirement's being met? Like, what have you done to determine that requirement's been satisfied?
That's in my professional opinion based on the character of the neighborhood and the proposed use of single-family residential development on this property.
But you had also indicated that you had not talked to the fire marshal yet, correct?
Correct.
And in the course of walking the property, did you walk around existing neighborhoods? Like, did you walk up and down Leon Drive or Grapevine Drive just to kind of see as a comparison to what you're proposing to build?
I did not walk, I did drive through that area.
Okay. All right, thank you.
Okay. As we hit 10 o'clock, sir, you could be the last one, that's fine. So you don't have any questions? Okay. All right, I see no more people standing waiting to ask questions.
Gentleman in the back.
Oh, sir, did you get party status? Your question's about getting party status? What is your name, sir? Richard Baum. Hang on, Richard Baum. Where's my list?
Hi, Mr. Baum.
Okay. We have a last-minute request, Julie, for party status from Mr. Baum. He is on the list of people within 500 feet. Do you have an objection to him having party status, or do you have questions you'd like to ask him?
I have an objection. I'll just note my objection.
Okay, Mr. Baum, what's your first name? Richard. Richard Baum. Okay. Tom, do you have anything to say or any objection to party status?
Baum is an adjacent property owner.
Okay. All right, Mr. Baum, you have party status. That means you get to ask a question, but I'm going to ask you, is it hard for you to get over there? I have a cordless microphone.
And I don't have questions, I just wanted.
Party status. Okay, you've got it. All right. Any other administrative matters or questions? Yes, sir. Nicholas. Okay, so just for the record, the question was, can the parties get copies of the exhibits? And the answer is yes. Let me figure out how to do that. We could have them emailed. I think that would be best. If everyone could provide their email address, we could do that. Right, Aaron? Okay. Yes, ma'am. You have a question? Hang on. What's your name? Catherine Shute. The list of people within 500 feet have been attached to the notice, the certificate of mailing. So that's one of the board exhibits. I can make that public as well, if you're interested in that. Sure. Anybody else?
I actually had a question.
Yes, sir.
Given that the property is kind of, I'll call it bound by limited emergency access, has any consideration been given to emergency access through the school district property they own?
We did consider other options. The paper streets that are shown in that area are no longer able to be used. So based on a lot of other constraints, we no longer explored that option after we determined we have access through the 20-foot wide easement out to our villa.
Julie, do you have an extra exhibit book for the manager? He didn't get one. You do?
Oh, I'm sorry about that. I thought
Oh,
I
you
gave-
want?
Oh, email? Sure, certainly, absolutely.
Okay, so it's 10:04. I have slotted for the next hearing in this matter to be the fourth Wednesday in May, and that is May 22nd. So what's going to happen is I'm going to ask the board to pass a motion, consider a motion to continue this hearing until Wednesday, May 24, 7:30 p.m. prevailing time. Let's do that first. What happened?
22nd.
Oh, sorry. May 20, I'm in the wrong month. May 22, 7:30 PM prevailing time. Is there such a motion?
So moved.
Second. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
All right, now that that's done, what I'm going to ask is for anyone who is a party to please come up. I'm going to get your email addresses from you, and then we will be sure to circulate the exhibits. Julie, when do you think you'll be able to send them over? Tomorrow's fine? All right, let's just say Friday, just, in case you need a day to scan stuff. And then we'll send it out. Yes, ma'am. So the question is, are people who did not come tonight able to come at the next hearing and request party status? They can request it, and we will adjudicate that when we reinstate this hearing in May, okay? All right, no promises, but we'll consider it. Okay. Yes, last question of the evening. Yes, sir. Well, I'll tell you this much. This is the applicant's case. And by law, they can call 20 witnesses if they want to, and they can change their game plan at any time. They can ask witnesses in the direct. They can ask redirect. There's rebuttal. There's sur-rebuttal. So I think right now Julie said that she envisions 2, but that may change as things evolve. So that's pretty much the best answer you're going to get. No, the applicant doesn't have to notify the parties as to their case. It's their case. They paid the fee. The law protects their application and how it proceeds, so she can run her case any way she wants to. Okay? All right, that was supposed to be the last question.
Me.
What's your name, ma'am?
Kelly.
Go ahead, Kelly. Wait a minute, we're not asking questions of the witness anymore. We're done with that.
Or the attorney.
No. Yeah, so the attorney doesn't answer questions. Witnesses answer questions. If you'd like advice as to party status, you have to consult an attorney. Okay? I can't give you advice. She's not going to give you advice. He's not allowed to give you advice. Okay. It's kind of, we all wear different hats. All right, we're done. Anybody who wants to get exhibits, come on up and give us your email, and we'll see you.
We got to exit the meeting.
We got to close the meeting.
Oh, hang on. We got to close the meeting. Do you have anything else to do? Public comment and then adjournment.
All right, hold up. We need 1 minute of your time because we need to close out the meeting. It's a formality unless somebody surprises us and they need citizens' comments. Are there any citizens' comments on non-agenda items? Okay, seeing none, then what we'll do is I'll entertain a motion to adjourn.
So moved.
Motion by Vice President
Second.
Rogers. Second by Commissioner Lustracco. Any questions or concerns? Hearing none, we will adjourn. All in favor say aye.
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 Opposed? Hearing none, we're adjourned. Thanks for coming out, folks.
Thank you, everyone. Thanks for your courtesy.
There you go.